Okay, let's get into it. We are diving into a ruling that is just, well, it's pure legal strategy.
So it really is. It's a
A
masterclass.
masterclass in how evidence that you'd think would be totally off limits gets strategically brought into a really high-stakes civil trial. We're looking at an order from the Southern District of New York. The case is Christoph versus the City of New York.
That's right. And for you listening, this is not just some dry case summary. We're going to look under the hood of federal litigation. We're going to see how a judge uses these very precise, very technical rules.
When you talk about the evidence rules.
Yeah, Federal Rules of Evidence 404B and 403 to decide if these, explosive allegations of past fraud can be used against a key expert witness.
Right. And our mission here is to really understand the legal cheat code the defense used. Because normally, a court would never let you bring up a witness's past wrongs. It just taints the jury.
It's way too prejudicial.
But here the judge, senior judge Loretta Preska, she allowed it. And she focused everything on one single, really powerful concept, the witness's financial motive.
It all comes down to money, and it shows you just how precarious life can be for an expert witness when their entire business model goes under a microscope.
Okay, so let's start with the facts. How did this all begin? The defense didn't just stand up in the middle of the trial and yell this outright. What was the move?
No, it was a very calculated pretrial maneuver. They filed a motion in Ladovin.
So a request to the judge before the trial even starts?
Exactly. They asked for permission to cross-examine the plaintiff's main medical expert, a Dr. Sebastian Lattuga.
And what were they alleging about him? This wasn't like a minor billing dispute.
Oh, not at all. The allegations are severe. They wanted to ask him about his involvement in what they called a scheme, and I'm quoting here, to recommend and provide fraudulent medical treatment protocol to patients whose cases are in litigation for profit.
For profit. That phrase says everything. It implies a system.
It implies a business model. And these allegations, they came from a third-party complaint for fraud. Now, that complaint was later withdrawn, but the details are still startling.
Okay, so what were the details?
The alleged scheme involved two things: providing inflated fees and, more importantly, unnecessary medical treatment. But here's the twist. This is the part that I think really caught the judge's attention.
Go on.
Dr. Lattuga, through companies he co-owned, was allegedly lending money at interest to the patients to pay for these very same unnecessary procedures.
Hold on. Wait a minute. He's recommending treatment that's supposedly not needed.
Yes.
And then his own companies are lending the patients the money to pay for it and charging them interest.
That's the allegation.
Wow. That's not just a conflict of interest. That is a self-sustaining financial engine that runs on litigation.
It's a complete cycle of profit. And that is exactly the financial bias the defense wanted to show the jury. And they connected it right to this case, the Fiquet case, by linking Dr. Lattuga to the doctor who referred the patient to him, and Dr. Leon Reifman.
Dr. Reisman, if I remember the source material, he comes with his own set of problems.
A tremendous amount of problematic baggage, yeah. The court order specifically mentions that Dr. Reifman has been the subject of five RICO fraud lawsuits.
5 RICO suits. For you listening, RICO is normally what you hear about in organized crime cases. That is staggering.
It's staggering, and on top of that, he had also had his license suspended by the Workers' Compensation Board for misconduct.
So the defense's theory isn't just that Dr. Lattuga made a mistake here. It's that he might be part of a much wider, financially corrupt ecosystem.
Exactly. And so you have the two sides. The defense says this is all relevant to his motive and credibility. And the plaintiff is, of course, saying, no way. This is ancient history. The complaint was withdrawn. It's totally unfair, and it's incredibly prejudicial.
Which sets up this perfect legal battle for the judge. She has to weigh these explosive allegations against the rules that are designed to keep trials fair.
And that brings us right to the legal plumbing, right? The rules of evidence.
Okay, so let's break that down. What's the main rule that's supposed to prevent this kind of character assassination in court?
It's Federal Rule of Evidence 404B1. Think of it as a shield. It says you can't bring up someone's past crimes or wrongs just to argue that they're a bad person, and so they probably did a bad thing this time, too.
Right. So you can't just say he allegedly committed fraud before, so he's probably committing fraud now. That's called propensity evidence, and it's banned.
It is absolutely banned. But, and this is the crucial part, there's an escape hatch. Rule 404B2. It's a list of exceptions.
And the exception, the magic word the defense used here was motive.
Exactly. The evidence can come in for other reasons, things like proving motive or opportunity, intent, a plan. And here, the defense wasn't arguing that Dr. Lattuga was a bad doctor. They were arguing that this whole prior scheme shows his financial motive to give certain testimony.
But isn't that a really fine line? I mean, how do you separate arguing he has a motive to lie from just arguing he's a liar?
That is the essential tension. But the court saw distinction. It's not just about his general character, it's about a specific financial structure, a system that benefits him when litigation goes a certain way. It's not he's a bad guy, it's he has a very specific financial reason to say what he's saying right now.
Okay, so it clears the 404B hurdle, but there's still one more gatekeeper, right? The big one, Rule 403.
The big one, the judicial safety valve. Rule 403 says that even if evidence is relevant, a judge has to exclude it if its value in proving something, its probative value, is substantially outweighed by the danger of unfair prejudice.
And this stuff is radioactive. You mentioned RICO fraud, lending schemes.
Yeah.
A jury is immediately going to be prejudiced against this witness.
Of course. So the question for Judge Preska was, is the defense's need to show this financial motive so important that it justifies that undeniable risk of prejudice?
And she came down firmly on the side of the defense.
Emphatically. Her core finding was that this evidence was, quote, highly probative and relevant to Dr. Lattuga's motive. Not just relevant, highly probative.
Which tells you she really bought into the defense's strategy.
She did, and she backed it up by pointing to how the Second Circuit, the appeals court for New York, handles this. They take what's called an inclusionary approach to Rule 404B.
What does that mean in plain English? An inclusionary approach.
It basically means the court leans towards letting evidence in. If the evidence can be used for any legitimate purpose other than just proving bad character, and motive is a very strong one, the default is to include it, to let the jury hear it.
So it gives the defense a lot of room to maneuver when it comes to witness credibility.
And a huge amount. And the judge cited a key case, United States v. James, which says the bias of a witness is not a collateral issue.
That phrase sounds important, not a collateral issue.
It's critical. It means you are allowed to bring in outside evidence, extrinsic evidence, just to prove a witness has a reason to be biased. The court even said that questioning Dr. Lattuga on his motive here was an essential element of the defense strategy.
So to deny them that would be to get their whole case.
It would cripple their ability to challenge the plaintiff's medical claims. And she pointed to other cases, like LaFlamme and Willoughby, that allow even uncharged conduct things that never even led to a lawsuit to be used to show motive.
So she grants the motion. But back to Rule 403 for a second. How did she get around the prejudice problem? I mean, how do you say that this isn't unduly prejudicial?
Well, she has broad discretion, and she's essentially made a judgment call. She said that in the specific context of expert testimony, where someone is paid for their opinion, the need to expose potential financial bias is just so high that it outweighs the risk. The jury just has to hear it.
It's a calculated risk then. But did she offer any way to manage that risk, to put a fence around this information so the jury doesn't misuse it?
Yes, and this is the standard procedure. The court said it will consider giving the jury a limiting instruction.
Ah, the limiting instruction. Tell the jury what they can and can't do with the evidence.
Exactly. The judge will explicitly tell them, you can consider these allegations of past fraud only for the purpose of evaluating Dr. Lattuga's financial motive and his credibility. You are forbidden from using it to conclude he's just a bad person who commits fraud.
So she's trying to thread an incredibly fine needle there.
She is. It's an attempt to control how the jury processes this explosive information. She knows it's prejudicial, but she's putting her faith in the idea that a clear instruction can curb the worst of it.
Okay, so let's synthesize this. We have the allegations, the rules, the ruling. What's the final practical takeaway here from this order on December 30, 2025?
The takeaway is that this is a massive, massive strategic win for the defense. It means Dr. Lattuga is going on the stand, and he has to defend not just his medical opinion in this case, but his entire business model.
The door is wide open.
Wide open. The allegations of the scheme, the link to the doctor with 5 RT suits, it's all coming in. And that just fundamentally changes the game for the plaintiff.
So for you, our learner, why should you care about this one specific order from a New York district court?
You should care, because it is a perfect and I think stark example of the level of scrutiny that expert witnesses face in federal court. It shows that any potential financial bias, any conflict of interest, even if it's based on allegations from a withdrawn lawsuit, can be used to completely dismantle that expert's testimony.
It basically says, if your expert's business seems built to profit from lawsuits, A jury has a right to know that. The motion to cross-examine Dr. Lattuga was granted. Full stop.
That's the bottom line. We saw how Rule 404B's motive exception opened the door and how under the Rule 403 balancing test, the court decided that showing this potential financial bias was just too important to keep from the jury.
So let's end on that final piece of the puzzle, the limiting instruction. It leaves us with a really important question for you to think about.
It really does.
The judge is going to let the defense bring up organized fraud, RICO, lending money at interest to patients. And then she's going to turn to the jury and say, okay, now, use this information only to evaluate his motive, not his character.
So the question is, what does that tell us about the court's faith and a jury's ability to compartmentalize? I mean, really, can a juror hear all of those explosive details and truly use them just to judge financial motive while completely ignoring the overwhelming temptation to just conclude that this person is fundamentally dishonest?
Can you actually unring that bell once it's been rung so loudly in a courtroom? That's something to mull over.